Most legal teams think that once they've written an internal AI policy, they're safe. They're not. A policy controls usage, but governance controls liability. So in this video, I'm not talking about tools or prompts. I'm talking about power structure. Who approves AI systems? Who carries fault when one hallucinates into a matter? Who can prove the firm acted responsibly when something goes wrong? If you don't have clear guidance, you don't have protection. You have hope. I'm Rok, founder of MPL Legal Tech Advisors. We consult legal teams turn risk into operational clarity, not by writing 40-page manuals, but by installing defensible control systems. So let's get clear on one thing before we build anything. Governance isn't a checkbox, and it's not a committee. It's a chain of accountability, and most firms don't have one. If governance fails because there's no ownership, no visibility, and no evolution, well then the fix is simple. ISO 42001 and NIST-RMF look great on paper, but most legal teams are not operating in a lab. They're governing tools already in circulation, half approved, half undocumented, used across multiple departments without supervision. Governance doesn't start with compliance documents. It starts with classification, so you know which AI systems actually require heavy controls and which don't. You install a repeatable control cycle. And here's the golden rule. If your governance takes 3 weeks for approvals, people will just route around it. Governance that is slower than shadow AI, it's just paperwork. This is designed to be faster than improvisation, and that's why firms actually follow it. Let's start with the most important piece. Who's actually in charge? First thing you have to do is assign ownership, because governance often fails for one reason, which is nobody owns it. If AI risk belongs to everyone, it belongs to no one. So here's the rule. Name 3 people and put their names in writing. AI lead, and it must be a lawyer, not an IT person. They will approve tools and make final calls in gray areas. Second one is the technical checker. That's the person that can actually read the vendor terms and flip the data retention switch to off. And the third one is the ethics and/or compliance verifier. Does this cross privilege or professional duty? They should meet on a regular basis, once a month, but not to discuss the latest AI trends, but to answer one question. What AI was used, and did anything require a decision? In these meetings, they log only the decisions. Date, tool, and decision. Nothing else. Because when something goes wrong, and it's crazy to expect it never will, you don't defend yourself and your firm with policy documents. You defend yourself by showing who was responsible and what they decided. And that's governance. And if you want this ownership structure installed without any political drama, that's exactly what we do for legal teams at MPL Legal Tech Advisors. You'll find the link for a consultation call below. Second, visibility. If AI use isn't logged, you can't govern it. You're just left guessing. Every AI workflow in the firm, research draft, intake summary, email edit, they should all end up in one central registry. You just need one spreadsheet with 5 columns. Task, tool, risk tier, reviewer required, and last time verified. You don't need any essays, you just need a few notes, just evidence. If someone uses AI outside of that register, it's automatically out of policy. And here's the leverage point for leadership. A register isn't administration, it's your defense file. When an insurer, regulator, or client asks, "Show us how AI is being used in your firm," that spreadsheet, that's your answer. One source of truth, only one place to check. Once it's written down, you can enforce it. Now, we all know that rules don't matter if no one checks whether they're followed. So governance needs a review loop. More explicitly, 2 layers. Live review on high-risk tasks. For example, if AI touches legal reasoning, client-facing wording, or anything marked red tier, it must be signed off by a partner, or whoever your policy names. That decision should be recorded and not assumed. Name, date, outcome next to the file or in the register, and a quarterly audit. Every quarter, pull 3 AI-assisted matters at random and check. Was the AI use logged? Was it reviewed by the right person? And was the output stored in the right location? If any of the 3 fail, adjust or tighten the rule, retrain, and keep the evidence of correction. And this is what makes the governance defensible, not just written. Next, even with review in place, your environment keeps changing. So governance needs eyes on updates and regulation drift, track tool and regulatory changes. Governance fails the moment the firm freezes while the ecosystem moves. So one person, that's your AI lead, owns the surveillance duty, not monitoring usage. That's your register. Monitoring change. change. Every month, they need to scan 2 streams. Upward, new bar guidance, ethics opinions, and court protocols. And downward, tool or vendor updates that touch confidentiality, retention, or supervision features. If anything shifts risk, you trigger a mere review on that tool or workflow only. You don't need any committees or rewrites. Has anything we previously approved become unsafe? Yes or no? If yes, update the boundary, log the decision, and move on. Why this matters is that firms that are getting fined or embarrassed aren't reckless. They're stale. They approved the tool 6 months ago and never checked when the retention rules changed. Governance isn't set and forget. It's watch and adjust. And when something does go wrong, because it will, you need the next layer. And that's the incident handling protocol. Even with rules, somebody will paste something wrong into the wrong tool. And that's the moment where most teams panic, or worse, try to hide it. Governance assumes mistakes will happen and prepares the response before they do. So the rule is simple. If something goes wrong, 4 steps. No improvisation. First, stop the use immediately. Pause access to the tool or block the workflow. 2, notify the AI lead. No gossip over internal channels. 3, document the facts in 3 lines. Who, what, when. 4, apply the correction. Access removed or retraining issued. And don't stop there. Figure out how you can prevent that in the future. That entry, even if it's just a timestamped note in the log, does more to protect the firm than any disclaimer or policy statement ever will. Without a documented response, it's a concealment. With one, it's a controlled remediation. And that discipline sets up the final piece of the loop, turning governance from cost control into value evidence. Which brings us to the ROI tracking. Governance often gets treated like a cost center, something you have to do because insurers, regulators, and bar ethics say so. Flip it. Every quarter, tally 3 numbers. How many matters used AI, how many hours it saved, even if it's a rough estimation, and how many errors were caught because review was in place. And had 0 confidentiality incidents turns AI oversight from bureaucracy to proof of operational advantage. And it also shuts down internal skeptics and gives partners something defensible to bring into the insurance renewal call. This is how you turn governance into evidence we're running tighter ship than competitors. Because once you track value, you're not just controlling AI, you're justifying it. And we came to the last section, which is renewal and improvement loop. As I said, governance isn't set and forget. It has to sharpen over time or it decays. So every 6 to 12 months, run a lightweight governance review. 3 moves. Remove dead tools. If no one used it in 6 months, drop it. Unmaintained tools become silent liabilities. Update the rules where mistakes happened. If there was confusion, misuse, or a logged incident, rewrite the rules so it never happens twice. And 3, add 1 new safe workflow. Don't chase shiny tools. Expand only where proven, reviewed, and reusable. This cadence keeps governance lean but alive. And when leadership sees removal, plus correction, plus expansion, logged on paper, that's when governance becomes defensible, not decorative. It's a loop. Ownership, register, review, audit, respond, and refine. If you can prove those 6 steps when asked, you're protected. And if you can't, you're exposed. Whether you lead a law firm or an in-house team, one rule applies. The moment AI starts touching contracts, investigations, HR disputes, or regulatory correspondence, legal becomes the control point, whether you volunteered or not. You can either define the guardrails now or spend the next year reacting to tools rolled out by IT, procurement, or individual staff. If you want legal control over AI without becoming the department of no, that's exactly what we do for legal teams at MPL Legal Tech Advisors. Book a consultation call below. If this helped, share this with your GC and follow along for more no-fluff frameworks and case studies in the future. Thanks for watching and see you in the next one.